SafeSport hearing process is governed by the SafeSport Code. There are 3 types of hearings under the Code: temporary measures, hearings related to criminal dispositions, and merits hearings. In each of these instances, a respondent will have received a notice from the center about how and when to request a hearing. Individuals agree to resolve disagreements with the center's decisions through private arbitration. The parties to an arbitration are the center and the respondent. The SafeSport hearing process is initiated by a request from a respondent upon receipt of a notice of temporary measures or notice of decision. SafeSport arbitrations are managed by the independent national arbitration firm JAMS, a panel of arbitrators, former judges, and practicing attorneys who have a background in matters similar to those handled by SafeSport. Generally, SafeSport hearings are held telephonically or through video conference. A respondent may have a single advisor who may, but need not be, an attorney. Respondents are responsible for initial payments of the fees of the arbitration to JAMS. A hardship exemption may be available for those who qualify. Temporary measures hearings are governed by Rule 40. A respondent has a right to a hearing within 72 hours of the request, although a respondent can request additional time if needed. A temporary measures hearing is not a hearing on the merits of the allegations, meaning that witnesses are not typically called to testify. It is instead a hearing to determine in the arbitrator's opinion whether the center has sufficient grounds to support imposition of the measures. The arbitrator will issue their decision within 24 hours of the hearing. Criminal disposition hearings are governed by Rule 14. The hearing addresses whether the center abused its discretion in rendering its sanction. A merits hearing is the most like a trial. JAMS will issue a list of potential arbitrators. Each side may strike 2 of the arbitrators from the list. JAMS will then choose the arbitrator from the remaining names. At the merits hearing, the center and the respondent offer opening statements, present documentary evidence and witnesses, and offer closing statements. The hearing is de novo. The center has the burden to prove its case by a preponderance of evidence. The rules of evidence do not strictly apply, and while the investigation report and notice of decision are admitted as evidence, they are owed no deference. Within 7 business days of the hearing, the arbitrator will issue a written, reasoned decision. The decision is final and binding to the extent permitted by law.